The Centre and the Gujarat government on August 17th justified the decision to allow premature release of 11 convicts in the Bilkis Bano case by arguing that they did not commit rarest of the rare crime and should be given a chance to reform and reintegrate into society. The Supreme Court asked why the remission policy was implemented selectively and why many similarly placed prisoners continued to languish in jail. Countering the contentions of Bilkis Bano and other petitioners against remission for the convicts, Additional Solicitor General SV Raju, appearing for the central and state governments, told a bench of justices that the offence committed by them was not the rarest of rare category, as they were not awarded that sentence and instead were given life imprisonment. Bilkis was 21 years old and 5 months pregnant when she was gang raped during the communal riots following the Godhra train burning incident. Her 3-year-old daughter was among 7 family members killed in the riots. The Centre and Gujarat government lawyers submitted that the crime, though heinous, should not be dangling over the convicts' heads and they should be permitted to reintegrate into society after having spent more than 14 years in jail. The lawyer also said that the law does not say that everybody be punished and be hanged, but it says that chance be given to people to reform. The bench agreed with the submission on taking a reformative approach. However, it highlighted the selective implementation of the remission policy and stressed equal opportunities for reformation. The bench of justices asked, why is the policy of remission being applied selectively? The opportunity to reform and reintegrate should be given to all prisoners, but only a few of them are given it. Question is whether the remission policy is being implemented when prisoners are eligible. It should not be en masse, but for those who are eligible for it and for life sentence convicts after 14 years in jail. The ASG said the decision on their release was taken on the direction of the Supreme Court, which had in May last year held that it was the Gujarat government and not the centre which had jurisdiction to decide their remission pleas. He said the court's order last year was binding on it, and while the bench may not agree with that, its effect could not be reversed now. Gujarat had revised its policy in 2014, under which the power to grant remission would be with the centre in cases investigated and prosecuted by central agencies. The Supreme Court had ruled against it and said the power would remain with the state where the offence was committed. As the Bilkis case was tried in Maharashtra, another question arose on which state would have jurisdiction to decide remission for the 11 convicts. The matter reached the Gujarat High Court, which said Maharashtra would have jurisdiction since the trial was held there. However, the Supreme Court ruled that Gujarat would decide the matter as the offence was committed in the state.
From breaking news, detailed analysis, in-depth interviews and explainers, follow the Times of India. Subscribe to our YouTube channel. Don't forget to like our videos and hit the bell icon to stay updated with the latest.